What an exciting time it is. And I'm really, really glad that I did not go, Mr. Prime Minister. Had I gone, I would have come back to participate in this anniversary. Because as you recounted, Sir Robert and I, and Professor Kaipu, we've lived this journey. I don't know what year, I think we all came, Mr. Kaipu in 71, at least Sir Robert and I. Sir Robert and I had the privilege of completing our secondary education in Australia, the same school, with the former public prosecutor, now Justice Sir Kinabona, Ambassador Robert Icey, and a number of others, and of course, history, as you read it, ladies and gentlemen, and the young leaders of tomorrow, the Gang of Four. Sir Anthony Siaguru was the first to be deceased, also was an Australian scholarship alumni. The advisor to our Constitutional Planning Committee, Nahau was an Australian alumni, educated offshore. Our first Chief Justice, Buri, was school captain at Ipswich Grammar in Queensland, going on to the University of Queensland, then marrying Dame Carol, coming back home to becoming our first Secretary for Justice and Attorney General, the advisor to the late Madam Nahau Rooney. Now, I'll talk about that affair in a moment. So these were the great giants of our nation that Sir Robert and I and Mr. Kaipu and Mr. Popman was already a lecturer, graduating in '74 before us, and here he is still alive and kicking as well. So 1975, as Prime Minister referred to, and Mr. Kaipu, we were rebel rousers at campus, seriously. The blood of patriotic nationalism was in our veins. Some of us who studied offshore had the benefit of following our development and our seniors from back here. And then the Gang of Four, some of the leaders whose names are part of our historical landscape. Sir Rabi, Sir McCarry, Sir Charles. Sir Charles studied offshore. Charles Lepani, the last of the Gang of Four, recently was deceased. Sir Anthony. Sir Anthony was in final year law, I think, when Sir Robert and I came. We played rugby together with McCarry. So I'm standing before you as one of the living beings of our Constitution, life, and so thank you, Sam, for the invitation to come and share this with you all. I could not have missed it for a lifetime. So 75, well 71, 72, as you know, we took partial government, full self-government in 73. Our founding father, Grand Chief, was Chief Minister then. A little bit of university history. In 74, I was Vice President to the President of Solomon Island named Bartulu Fahalu. He was our president. I was his vice president in 74. And one of our student exploits, like many of you know, was to protest and march down on Koninobu to increase our student allowances from a miserable $3 to $5. That's the pre-independence Australian dollar. So we organized at the student forum drove vehicles. I borrowed the university truck and transported our students down to Ella Beach, and we marched on Konedobu. There should be some photos somewhere. We marched on Konedobu where our self-government was based, and sat at the round table with the old man, Grand Chief. One of the lecturers from ESM, you remember John Cowie?
Yes.
He was doing, PK and the civic to civic, talking about increasing our, this is a great national issue, guys. Increase our student allowances. We protested, we marched, and then the aftermath of that was that some crazy guys continued to protest on campus and blocking traffic and burning cars. Some bougainvillean guys, Robert knows. And we kind of boycotted classes, over increased our student allowances. Then, that was 73, 74. 75, as the Prime Minister referred, I was President of the SRC. Sir Robert was Secretary, and the Vice President was Campus Narakobi. And you know that name also. Bernard's younger brother, Camillus. So, beginning the constitutional journey, one of multiple debates about the content of the CPC report. All of the pillars that we've now adopted, as the Prime Minister referred to, was the recommendation for adopting the British monarchy as our head of state. As history reports of our resolution on the forum floor, both the student body and some of our academics, we resolved to oppose it, the British monarchy becoming our head of state. And so we marched on Wagani. So Robert and I, we led the protest march, and we presented, I think, my memory fails me, but I imagine I did, as the President of the SRC, to the Chief Minister, Father Somare, opposing the recommended adoption of the British monarchy as our head of state. Leapfrog decades later, when I became Member of Parliament, in his government, together with the Prime Minister in 2007, becoming governor for Madang, and then 3 years later in 2010 becoming Minister for Justice and Attorney General, in a Grand Chief government with Prime Minister who was then Minister for Education. So I would just want to say to Father Somare, Chief, you and I have unfinished business. We need to amend this constitution and remove the British monarchy as our head of state. That's history. We're still part of the Commonwealth, and the British monarchy is our head of state as I speak. But as some of you should know, particularly law students and political science, that a couple of years ago the government commissioned the Constitutional Law Reform Commission to do a major review on the system of government. I think last year that they completed that review, and reports are with the government at the present time about the systems of government. Questions were asked, and I don't know whether you ever were made aware and participated in those surveys. I did vigorously in my church to speak about the constitutional issues that this review was posing, asking about the systems of government, whether we would consider a bicameral system of government. Presently we are a unicameral, one house only. Most of the democracies that we've modeled our constitutional democracy on have a two-tier house, a bicameral system, an upper house and a lower house. Another important question was whether we would retain the British monarchy as our head of state. So now you've heard my views. Let's now like we would say as lawyers and jurists, the jury is out on this subject. Is it, Mr. Prime Minister? The other was whether we would retain the three-level system of government. The Prime Minister referred to the decentralization model. We have the national system, we have the provincial, and we have the third-level arm of government, our district LLGs. Whether we would retain those or we will revert to just two. It's a major constitutional policy issue. What else was there? I think those were the main ones. Mr. Prime Minister and ministers and Chief Secretary. And so I refer to that as the challenge to you young educated elites of tomorrow. The Constitution is an evolving living document. The constitutional legal phraseology we ascribe to it is that it is autochthonous. It is homegrown. It is like the word we know, autonomous. We are independent, we are self-governing. So the word that legal eagles coined for our constitution, the living document, it is autochthonous, it is homegrown, as the Prime Minister referred to. The CPC traveling for nearly 3 years, consulting our people throughout the nation. So we adopted this constitution, this living document, and as a lawyer, ultimately a jurist for 20 years, and then a politician, and I should say, lest nobody knows, I am the only person who served in all three arms of government, standing before you today. And that's an aspect of a constitutional structure that I can allude to. And I will be speaking at the Bully Beef seminar in September 10th to the 12th, Mr. Prime Minister, the major 3-day conversation about celebrating our past and our future, including today. And that's why I was so blessed to still be here and ask Professor Kaiko to invite me to speak to you. And so the pillars of our Constitution are resilient. You've read what I might have said. I've written over the 10 years that I started as Chief Justice and 20 years in interpreting our Constitution, guided by the national goals and directive principles. Homegrown. Those were the pillars of how this living document was to evolve and develop to where we are today. As we speak, it is being challenged, some aspects of it. And so the question many have asked me, I've done a number of podcasts, I've been interviewed, and today I assert before you unequivocally that the Constitution is absolutely resilient. All of its pillars of a Western constitutional parliamentary democracy are resilient. Unless we tinker with it. It's only as good as we who administer it, who implement it, who interpret it, who apply it, make it so. So if we tinker with it far too much, then it will fracture. We are a constitutional democracy under the rule of law, like the Prime Minister referred to. And as you read some of my thinking that has grounded the constitutional democracy and its independence and strengthening the three principal arms of government. It's the roadmap for our future, as the Prime Minister referred to. And we who are the legal eagles in this room and in the profession, some of the leaders will be here talking about it in the course of the day, we are the custodians of this document. We are the legal eagles who ought to give the principal advice and advocacy to support, sustain, and protect that document. Together with our members of the other two arms of government, in the legislature and the executive, as we know, the three equal arms of government, subject to the Constitution as the pinnacle, No one is above that martial law. All three of our arms of government are subject to it, including the judiciary in particular. And therefore, it behoves us, when we interpret it, when we apply it with absolute integrity, impeccable reasoning process. And so some of the challenges that come with that, I should refer to it in passing because time does not permit us, and you and I could have more conversations later on about the different challenges in the 50-year history in the case law. First one, of course, was the Nahau Rooney Affair that I alluded to. The bench at the time was wholly expatriate. A lecturer at this university was engaged by one of the ministries to give some advice, as they do continually understand, and that's perfectly legitimate for professionals in this institution to become advisory consultants to the different arms of the public sector and private. There was an issue about his continued advice, and the government, cutting through the chase, decided to deport him. He took out the judicial review, obtained a restraining order in the national court, which is part of our fundamental pillars of due process, natural justice rights, protect your rights. And then the minister at the time, I think the second member of parliament woman, is that right, Sir Robert? Then Joseph was the first, and Naharuni. She was Minister for Justice. I was a senior lawyer at the Public Solicitors in 1979, a senior criminal defense lawyer in the Public Solicitor's Office. The first national public solicitor at the time was then later Sir Marape. So dispute arose, and cut a long story short, we can discuss the details later. She wrote that the National Court issued a restraining order against the deportation, wanted a review, as you and I know the law, and the issue of the constitutionality of the powers of government in the immigration law was then raised, and the judge, Justice John Pritchard, referred it to the Supreme Court for constitutional interpretation and granted the stay. Our Honorable the Minister wrote a letter to the Chief Justice at the time, Sir William Prentice, and took issue in a general political sense about nationalism and the rule of law and so on. That all escalated to a contempt charge against Nahau Rooney, our Minister of Justice, under Grant's Sir Michael's government in 1979. The upshot of it all was that she was found guilty of contempt of court. The law, I'm sure you senior law students have dissected and discussed. It ultimately led to her being imprisoned for 8 months. The Supreme Court came down firmly, protecting the independence of the judiciary and finding her guilty of contempt sub judice. Imprisoned her for 8 months. And if those of you who know the Constitution, that 8 months is 1 month short of 9 months or more, should you be so imprisoned, which would result in you being disqualified as a member of Parliament. So there was some measure of understanding there so that she was not disqualified. Again, the upshot of it, as many of you should know, is that the Prime Minister will then assume the Justice Ministry, as Prime Ministers are vested with all the ministries. They are the Prime Minister. And he exercised the power of clemency and released her from prison after 1 day. As you can imagine, that was led to a significant conflict and impasse between the judiciary and the executive. Of course, that decision by the Prime Minister prevailed. There's not a thing the judiciary could do about it except to find her guilty of contempt, ultimately resulting in an en masse resignation of the senior judges, including the Chief Justice, resulting in then the beginning of the localization process of our bench. First national judge was then the first public solicitor, my predecessor, Sir Marape. He became our first national judge, I think it might have been 78 or thereabouts. And then shortly thereafter, the same government of Sir Michael appointed Sir Murikilu, then the Secretary to Justice and Attorney General, Advisor to Nahau Rooney, as our first National Chief Justice. So that's a milestone decision that I'm sure you've studied many times. Leapfrogging forward, just a couple of examples, and I should then manage my time. Was when I then became Chief Justice in 1993. As you know, and it's an issue that I can allude to, that the fact that our judges presently are appointed 10 years at a time. All the other judges, the Deputy Chief Justice, and other judges are appointed by the Judicial and Legal Services Commission, which is chaired by the Attorney General. Should he be a lawyer, he's an Attorney General, like the present Minister's Attorney General Niningi. He's a lawyer. If you're not a lawyer, you're just a minister. As Naharuni was just a minister, she wasn't a lawyer at the time. And so, excuse me, it's okay. Judges are appointed 10 years at a time, and the Chief Justice is appointed by Cabinet, the National Executive Council government of the day. And so, I was then appointed, and 10 years later, I succeeded Sir Buri as I was then the 5th National Judge. Sir Marape was the first. Sir Buri was our first Chief Justice and 2nd Judge. William Caputin, the older brother of Sir John Caputin, one of our founding fathers, as you know the name. And then Narape. He was appointed an acting judge for a 1-year term. William Caputin served 3 years and moved on into private practice. Narape served 1 year as an acting judge and moved on to becoming a politician, as you know. I then became the 5th national judge, progressing to becoming the 3rd most senior after Sir Buri and Sir Marape. After Sir Buri's 13-year term as Chief Justice from 1980 to 1993, the government of Pius Wingti and Sir Julius Chan in 1994 decided to appoint me as the 2nd National Chief Justice. There was some issue about politics and all of that, which we can talk about as well. I was the 3rd in seniority. But that's the prerogative of the National Executive Council, as Prime Minister sitting here knows, and you as lawyers, you and I know. That's an issue that I want to flag. About the tenure of judges. In most common law jurisdictions in the Commonwealth, judges are appointed for life, meaning retiring age life tenure. So there is no issue potentially of politicization of the appointments of Chief Justices, in particular by the governments of the day. I've spoken of that on a number of occasions. And so, a year later, in 1994, Pius Wingti was Prime Minister. As many now know, the Wingti Case. In order to avoid the vote of no confidence at the time was imminent. After 18 months, as you know, is the current law. 18 months is the grace period, and after which votes of no confidence are open. And so on the eve of the expiry of that 18 months, as you know the law, most of you read it, studied it, dissected it, Pius Wingti, upon advice, I presume, decided to tender his resignation on the evening before, like today, when the Parliament was sitting, tendered his resignation to the head of state, which is, as we rule later on, valid upon receipt. And so he tendered his resignation with the view to avoid potential vote of no confidence at the expiry of the 18 months, when Parliament was sitting. Next day, the advice to the head of state was advised the Speaker to announce to the House that there is now a vacancy, the Prime Minister Wingti having resigned last night. And so there is now a vacancy, quote unquote, that's the key word, as all of you lawyers should know. And so they proceeded to take a vote. That was the political design, as we recounted in the judgment that you all read, that I read, plus others. And then proceeded to appoint him to avoid the 18 months grace period vote of no confidence that was imminent. Well, Chris Highland was the leader of the opposition at the time, and of course he challenged it to the Supreme Court. The constitutionality of whether or not that was valid. As you now know, the law that was established under my tenure as Chief Justice, and wrote the judgment that you all dissected, no doubt. That day, unfortunately, was wrong. Not that day, but it ought to be the next sitting day. That was the essential constitutional interpretation. It's not rocket science, but it's legal. Almost people can describe us when we do this kind of interpretation as being legal mumbo jumbo. So we ruled against him about 6 months later, that your election then was unconstitutional and the House must now proceed, because we accepted that your resignation was valid, but your re-election was invalid. And so the House then reconvened, and the result of it, as you know the history, Sir Julius Sandon became elected Prime Minister. So that's the Wingti case, strengthening, in my view, the earlier Nahau Rooney case, that they affirmed the independence of the judiciary. So the talk on the ground, I was subsequently a politician, so I can say this. Politics in the corridors was, well, Sir Arnold was appointed by Pius Wingti, so it is going to be a Pius Wingti decision. Well, that's what it means to become an independent judicial leader. The judges are independent, so you lawyers, when you are advising, like the PP and others, that we are above political reproach when you assume that position, and to uphold the integrity of the judiciary. So we ruled, I wrote a major decision, then unfortunately just a small technical glitch, almost. Should have been the next day, not this day. And it resulted in the change of government. So that affirmed the independence of the judiciary, the separation of the three arms of government that remains resilient today, except for 2011. The Prime Minister alluded to that. So, I'm going to speak to that and I'll stop. We can discuss details and Q&A later on. Going from Nahau Rooney, where the bench found him guilty of contempt for writing a letter, making a couple of public statements in the radio and TV about her disappointment about the judicial system. They found her guilty of contempt and sent her to prison. So, fast forward a number of decades later to when I was CJ. Would I have done that with my bench? You can ask me that later on. So 2011 came along when Prime Minister and I were in branches of Michael's government. The same issue of 145, the vote of no confidence, the imminent vote of no confidence, but the Parliament at that time decided when numbers shifted, our overwhelming majority of Grand Chief Sir Michael's government walked across the floor, led by Don Polly, William Bloomer, Sam Basil, and 22 of the members of our government walked across the floor, and the numbers shifted. And so instead of proposing 145 vote of no confidence, they decided to go all sorts of devious ways. That is in the law reports that you will study, no doubt. All of them fundamentally flawed. They firstly tried to prove that the old man, Grand Chief Prime Minister, was unfit to hold office. He was mentally incapacitated from having undergone surgery in Singapore. And so they wanted to declare that there was a vacancy as a result. It's like the Wingti case, when there was imminently to be a vote of no confidence. He avoided it by purporting to resign. And so the government, the opposition of Peter O'Neill, moved, as Prime Minister was alluding to declare the Prime Minister disqualified by reason of insanity, medically unfit, and thereby, as you know, the constitutional provision is not qualified to hold office, and there's a vacancy therefore, and so they proceeded to elect Peter O'Neill as Prime Minister. That went to the Supreme Court. The court found against them and asserted that Ranjit was not unfit on medical reasons, etc., and he's still the Prime Minister, and so the election of Peter O'Neill was invalid. They then proceeded to try other things like, and I'm sure you've done all these studies. One of them, and I'll just stop there and just make some bold statements to you, and I'll stop, was to purport, so you should know the law, that if you're absent from sitting in Parliament for 3 consecutive sessions, you are disqualified. So, Chief was in hospital in Singapore from about March. And so in May, the May sitting, we moved to grant him leave of absence for medical reasons. But we forgot in the next 2 sittings, I think it might have been June and August, thereabouts, the next 2 we forgot as the government of Sir Michael. And so one of the attempts to try and disqualify the Grand Chief, having failed in the first one, Supreme Court having held against him, was to move a motion to rescind the grant of leave we gave him in May retrospectively. This was in August. To move that that grant of leave should be rescinded, thereby rendering him absent for 3 consecutive meetings. Are you following the law here, lawyers? And thereby to then say you are thereby disqualified as a member for his civic, and the position of Prime Minister is therefore vacant. And so we proceed to elect Peter O'Neill once again, the second time around. Supreme Court convened again later in 2012 and ruled that that too was unlawful, because the decision whether or not to determine whether a member is disqualified, like I said, if you are sentenced for more than 9 months, under Section 103 of the Constitution, you're disqualified, or if you are absent for 3 consecutive meetings as a member of Parliament, you're disqualified, is a matter that is determined by the National Court, not by Parliament. And they made also, so, ladies and gentlemen, what I'm alluding to, and I see my time, and to say this, that was a constitutional coup that lasted for 12 months, unequivocally. I assert it to you and the nation today. There's been some wishy-washy debate on the floor of Parliament. As the Prime Minister knows, recently as I speak. And the Prime Minister spoke and alluded to this particular occasion, and there was some pushback by several of the leaders. They were wrong. Nothing the court, nothing that the Parliament did subsequent to those ever validated that coup and unlawful election of Peter O'Neill twice over, ruled against by the Supreme Court, and he held onto power by the use of compromising our disciplined forces, the military and the police force, and held onto power for 12 further months, illegally, unconstitutionally. The court had ruled, and so now I'm asserting it to you unequivocally today, to the nation. So nobody is going to be trying to say otherwise. For 12 months, all of our neighbors went silent on us. Unfortunately then, elections came around 12 months later in 2012. He got elected. Thereafter it was legitimate. Not the 12 months previously, from August 2011 to August 2012. So, contrasting Nahau Rooney's case with what happened in 2011 and the events after that, one of which was the raiding of the Supreme Court by the then so-called, quote-unquote, Deputy Prime Minister Hon to raid the Supreme Court and attempt to arrest the Chief Justice, sitting Chief Justice in the Supreme Court. What outrageous contempt that was! Are you hearing me, PNG? And nothing was done about it. Our wishy-washy National Court ruling subsequently exonerated him, found that the leadership tribunal that ultimately dealt with Belanama was flawed in penalizing him without giving him a right to be heard. What nonsense. Where else in the world do you raid the Supreme Court, attempt to arrest the Chief Justice, and in fact arrested him later on, together with Justice Kilwong, and you get away with it? So, ladies and gentlemen, I close my case. There are others going on as I speak. 145 is being challenged, as you and I know, and I better not say anything else, otherwise I'll be charged with contempt of judice. But we understand. That's part of the process. So,
Court is a good place to go.
Court is a good place to go. I say no more, sir. Yeah, so ladies and gentlemen, I think going forward, you are the ones who have got to uphold the rule of law. And we all, like the good old Bible says, the cloud of witnesses who are still alive can give you counsel. So thank you very much. I'm happy to talk to you about many other things, aspects of that. But let me say two things and I'll stop. Mr. Prime Minister and ladies and gentlemen, one major provision which I consider is a deficiency in our constitutional democracy is the provision for national referendum about amendment to the Constitution. I think there's a deficiency. When we are considering major reforms and amendments like I've alluded to of the review recently, there needs to be a structure and a process for nationwide referendum consultation. I know the CLRC has done some review, but that's insufficient. So that's one, and the other, sir, I think you've alluded to, and which is going to happen, which is a separation of the Supreme Court from the National Court with an intervening Court of Appeal. It's a good progress, but I would recommend going forward, whenever that issue on our government's desk of the legislature is to consider at an appropriate time that appointment of judges ought to be for life. I know there's a separation presently. They're appointed by an independent judicial commission, ordinary judges, deputy, and the others, and the CJ is the prerogative of the government of the day to avoid the arguments about potential politicization of the appointment of the Chief Justice in particular. So, I am presently still of serving age. When I was retired out and succeeded by Sir Marape. Sir Salomon, the immediate past Chief Justice, so much younger than me, still of serving age, when he was retired out and succeeded by Sir Gibbs. So that's a combination of nearly 30, 40 years of experience that we could do it. So going forward, as a matter, it's in the hands of the executive of the day. Thank you very much, ladies and gentlemen. Mr. Prime Minister, thank you for your time.